Hey everybody, and welcome to today's Chet Chats. Today I want to do a little bit more of a deep dive into the Kyle Rittenhouse case, specifically some of the evidence admissibility issues that we expect to see, some of the other ancillary legal issues that have been presenting themselves, and kind of respond to some things that I've seen on the news and social media and that sort of thing. I had a very good discussion with an attorney and friend. He's a friend first, attorney second. Somebody who I respect very greatly and think he's incredibly intelligent. We do have different viewpoints on this. We've had a very productive conversation, but it really got me thinking about a lot of things, and so I kind of want to unpack some of those thoughts. But like I said, even though I do have a different viewpoint than him on this. He's very intelligent, very honest, and I think very highly of his opinion. But so one of the things that I'm seeing are discussions about all these facts of a case, right? So we have things like the social media posts that he made days or weeks, or maybe even hours before he traveled to this location to participate with this militia. Things to the effect of, I'm going to show those protesters, like wait till I get there, something like that. Social media posts that seem to indicate a desire to get involved. Some could interpret that as a desire for retribution, if you will. We also have the fact that he called his friend after the first shooting, and said, hey, I just shot somebody, or I just killed somebody, as opposed to calling the police right away. There's that. There's the idea of his flight, or him leaving the scene afterwards. What else? There's the fact that he's 17, that he wasn't supposed to have a gun to begin with. What else? Different things. There's other things that we see thrown out there, and in my judgment, there are certain things that might come in to trial, but other things. My thought on the social media post is that it could potentially be inadmissible under Federal Rule of Evidence, and most states have adopted 403, unduly prejudicial, having minimal probative value. So this is something that, while technically might be relevant, the risk of unfair prejudice substantially outweighs its probative effect. And probative effect is just a legal way to say relevance. So why do I say that? Okay. And the main argument that I'm hearing about the social media post, about him coming from another state or whatever, it goes to mental state, right? It goes to his mental state, his intent to kill, his intent to do that. Okay, and so here's my response, and I think where maybe some of the breakdown in communication happens. I don't believe that his mental state is at issue in this trial. I don't believe his mental state is relevant, because in the legal sense, when we're talking about crimes, what is mental state, right? We use the term mens rea. Some of you may have remembered that term from Legally Blonde. We might actually touch on another Legally Blonde topic, but mens rea is the mental state at the time of the offense that can make someone guilty of a crime, right? So the mental state necessary for a theft, for example, is to permanently deprive the lawful owner of the use and enjoyment or ownership of that property. So if you had someone who picked up an item and put it in their pocket and walked out of the store, mental state would absolutely be relevant. And their defense of, oh my gosh, I meant to pay for that, I honestly just forgot, or I didn't intend to put it in my pocket, or I meant to put it back, I didn't intend to leave the store with it, their mental state would be very relevant. Okay, it's whether they intended to deprive the owner. Oh, well, I meant to put it back. My mental state was I was going to put this back before I left because I knew I didn't have money. That's mental state. his mental state, all right, in this case, he intended to kill, okay? When he shot those people, he did intend to kill. And that's always the case with a self-defense shooting. It's always the case that they intended to kill. If he didn't intend to kill, right? If the defense was, I didn't mean to pull the trigger, it was an accidental discharge, I'm trying to get a lesser included offense of involuntary manslaughter, something like that, then his mental state would be relevant. Then his mental state would absolutely be pivotal in that trial, and saying, well, look at all the social media posts he made. He came here to do X, Y, and Z, and now he's saying, oh, no, I was just standing there and the gun accidentally went off. In any self-defense shooting, you intend to kill the person. The defense is that you were entitled to because you were reasonably in fear of death or serious bodily injury. That's the distinction. So in my judgment, mental state is irrelevant because the defense is not claiming that he did not intend to kill him at the time he pulled the trigger, and shortly before that, he intended to kill or at least inflict serious bodily injury, which is, for these purposes is the same. So it doesn't matter. And so the risk of unfair prejudice is demonizing this kid, and it's important to remember that he is a minor, demonizing him and, painting him as some vigilante. Another thing that I want people to think about is, okay, so he wasn't supposed to have the rifle because he was a minor, right? So he was, committing a misdemeanor offense by doing that. It wasn't his neighborhood, so he was, whatever. When he was standing in the parking lot, at 11:30 at night, while this mob was there, and this one guy that started, the first victim, bald-headed guy, convicted sex offender, which, by the way, I agree that his status as a convicted felon would not be admissible in the trial unless Kyle Rittenhouse knew of that fact and had firsthand knowledge of his reputation for violence. I agree that the sex offender or pedophile, or whatever he is, that would not be something that would properly be admissible in the trial. So I just want to get that out there, that I agree that wouldn't be appropriately put before the jury. And if anybody has questions about that, please feel free to comment, and I'll go into more detail on that. But I want to be fair and balanced. But what I was saying was, if you think he was in the wrong morally, at what point in time did he lose his right to defend himself? And that's the question you have to ask yourself: is did he relinquish his right to defend himself by virtue of the fact that he was a minor in possession of a firearm? Did he relinquish his right to defend himself by the fact that he made a social media post, a distasteful social media post, a few days earlier? When he was standing there in a parking lot in front of this mob of people, and this guy started running at him and then threw something at him. We still don't know what it was. Some witness reports think that it was either a brick or a Molotov cocktail or something to that effect inside that plastic bag. And then after he fell down on the ground, and this guy continues to aggress towards him, continues to run towards him, did he not have the right to defend himself at that point in time because of a social media post that he made a couple days ago? I mean, I want to know the answer to that. I want someone, if you think that Kyle Rittenhouse is guilty, okay, and I'm not making a value judgment, I'm telling you legally what follows from your conclusion. You have to believe, and I'm going to paint this in even the most positive way possible, he should have been limited to non-deadly force in that case. That he could have defended himself by maybe pushing or something, but he was completely unjustified in using deadly force against the guy who was running towards him, threw something at him, and continued to come towards him after he'd fallen on his back. And the big caveat is Kyle's holding a rifle. I mean, he's open carrying this rifle. So what does he think is going to happen if some guy who's attacking you, and if you don't neutralize the threat? I mean, this person is very likely going to take the firearm away from you, very likely use it against you. So I guess my question is, at what point in time, what did he do that caused him to lose his right to defend himself? And I say that that is a very heavy burden of proof because it's not supported in law. Okay, there is no jury instruction. There is no statute that says that you lose your right to defend yourself unless you are an instigator or unless you are not legally where you're supposed to be. Okay, and when we say instigator, you can't say, well, he instigated it. Because, no, that's not what, you're not an instigator because you go somewhere where a violent encounter may, potentially may happen. When the law uses the term instigator, it's talking about you actually going up, pushing someone, yelling at them, instigating a specific person. And I think that's the distinction, is people want to talk about his intent to kill or his intent to do all this stuff before he came to this group. It wasn't towards any particular person. It was just, but that's kind of neither here nor there. But he's not an instigator in this sense. If you watch the video, Kyle goes up and puts out a fire that the mob started and that they were going to use to further vandalize private property. He takes a fire extinguisher and puts out the fire. Well, they don't like that. And this guy, this bald-headed guy, yells at him, cusses at him, gets in his face, ultimately chases him. So Kyle was not the instigator of that interaction between himself and the decedent. He was not legally the instigator in that situation. He wasn't where he was supposed to be. This could be a little bit of a gray area, right? But when the law talks about that, they typically mean you're trespassing somewhere. You can't claim, let's say, a stand your ground law if you're trespassing in someone else's house. I mean, and the reason that law exists is to prevent a situation where I trespass in your house, you go to kick me out and shove me out, and then I claim that I'm defending myself to try to fight back to you. I can't do that. I'm not supposed to be in your house. So that's the context in which that law is typically interpreted and applied. So there is no law, there's no case law, there's no statute, there is no jury instruction, at least in the several states I've practiced criminal law in, there's no jury instruction that says, well, the fact that the person reasonably apprehended the likelihood of a violent encounter occurring, the defendant loses their right to defend themselves. That's not a jury instruction. That's not the law. And I want you to think about the policy implication of saying that someone has a diminished right to defend themselves simply because a potential violent encounter was foreseeable. Think about that. I mean, so the guy who, runs to, aid, he finds out that a bank's being robbed, and he runs in and he sees the bank robber. The bank robber points his gun at him. The guy pulls his gun and shoots him or whatever. Clearly self-defense. But if people want to say, oh, well, you put yourself in that situation, so you can't defend yourself. Well, no, that's not the law. I mean, as long as you're legally doing something that you're legally allowed to do, then if the events transpire such that you are justified in using self-defense, then you're justified in using self-defense. So, yeah, I know this video kind of took a turn. It's just some things that I really wanted to articulate. I'm not trying to make all the facts are not out yet. I'm not trying to make an absolute judgment call. I'm just trying to, like I said, articulate what I think the law is regarding self-defense, what it isn't. We talked about the social media posts. His flight, I think his flight is admissible because it'll go towards guilty conscience, and that's something that can be explained by his attorney. The fact that he called his friend instead of the police, and he said, hey, I just shot somebody. That I definitely think that'll be admissible to the extent that they want to interpret that as him bragging. But, we're talking about a 17-year-old. We're talking about a kid. And, you know, just because someone responds in kind of a weird way or kind of a distasteful way, that doesn't mean that what they did was not legally justified. Like I said, I'm of the school of thought, and respectfully disagree if you don't agree. You look at the encounter, right? You look at it when we're judging whether self-defense was justified or not. You look at the encounter between the two people. And usually if there's a video, oftentimes you can look at that encounter in a vacuum and you can see who aggressed towards who tried to retreat. That's another thing. Kyle ran from this guy. Everybody that's saying he went there looking to kill, looking for a reason. Well, the second the bald-headed guy stepped towards him, if I'm Kyle's attorney, what I'm arguing is he would have just shot him right there. And then try to claim self-defense. If he was looking for an opportunity to shoot someone at the first chance he got, you know, or just looking to smoke somebody in this vengeful vigilante sense, you know, I don't think he would have ran away from the guy. So anyway, those are my thoughts. Sorry that this video is a little bit longer. I try to keep around 5 minutes. I don't think I could have done this justice in that amount of time. So those are just some of my thoughts. I hope you guys find this educational.